Hi there, and welcome once again to Employment Hour in 30. If it's your first time, come on in. Water's warm. If you're joining us for maybe the 15th time or so, glad to have you back. We talk about employment law, your severance, your workplace rights, temporary layoffs, which, by the way, is going to be on the cards today. So we got lots to get through. 1-855-821-5900. Anytime you want to contact Lior, a member of the team. And it is also help@employmentlawyer.ca. That is the handy dandy email. But first, lots to get through today. Want to get to a week that was. What's up, pal?
Been very busy, you know, as we're getting through with the year. A lot of people are calling me. Sometimes changes happen. Sometimes they don't happen necessarily right at the beginning of the year. They happen later on. And because of that, problems arise. It'd be nice if we all worked in a place and there's never any problems. Things go great, smoothly. We're working there as long as we want. But unfortunately, for many people, that's not the reality. Sometimes you may have workplace issues, workplace problems, workplace concerns. If that happens, we're here to educate. We're here to talk about those things exactly. But if we don't address your specific topic or you want to ask specific questions for yourself, call me. Let's talk about that. Let's email. Let's make sure that those problems are answered and they're solved. And week that was, the reason I start off that way is because by talking to you, by outlining a scenario, you may find something there to identify with. You may find something there that applies to you and you learn something new by it. So week that was, I spoke with a gentleman who called me what initially seemed to be a regular severance package review. He was let go after about 10 years of employment. He was offered about 20 weeks pay, let's say call it 5 months pay, was completely inadequate. Yep. And I talked to him about it. I explained that he's probably owed about a year's pay, you know, more than double what he was actually offered, and kind of we left it at that. Well, in talking to him and talking to him further and how I'm going to help him, he also mentioned something interesting to me, that in 10 years that he's been working there, he had never gotten paid overtime. He was a machine operator, but on salary. So I said, well, wait a second. Why did you not get overtime for 10 years? Well, I'm not an hourly employee, I'm on salary. And because I'm on salary, my employer always said, well, you don't get overtime. It's all included for 10 years. And he regularly, John, worked anywhere from 48 to about 52, 55 hours every single week. A lot of overtime. Yeah. So here's the thing. The bad news, I told him, is that 8 of those years we can't do anything about. But the good news is we can still go back and get you 2 years worth of overtime. And for him, that's about $15,000, a lot of money. And I wanted to bring this up here for a couple of reasons. Number one, to remind everyone that if you work, even if you're on a salary, you get overtime if you work more than 44 hours a week. Again, 44 hours a week, anything over, you get paid time and a half, even if you're on salary. Very important to remember that. The second thing is that's why it's so important to get some advice if you lose your job. Because it's not just about the severance, even though that could be a big portion of it. You may be owed other things. In some cases, in this case, it's overtime. But it could be bonuses, it could be car allowance, it could be benefits, it could be many other things. So always important to get that advice if you lose your job.
I mean, a natural question, anybody watching this that doesn't know what we do in depth is think, okay, I'm a salaried employee, you say I get overtime, but I'm not an hourly employee. How do I calculate how much do I get?
Yeah, so let's talk about that. Whatever salary you make in a week, maybe it's $500, maybe it's $1,000, whatever you earn in a week, divide that by 44, okay? So if you make $500 a week, 500 divided by 44, that gives you an hourly rate. 1.5 times is your overtime rate, which it has to be paid over 44 hours a week. So you get paid overtime hourly or salary. There's some exemptions. Sure. For example, managers don't make overtime. But beyond that, most people do get overtime. And if you don't get paid overtime, your employer is doing something wrong.
EmploymentHourTV.ca is a good resource for you to find out where you can catch our weekly radio show, which we've been doing for, I guess we're working on 7 or 8 years now. No, longer, maybe even longer than that. It seems endless, but that's a good way. From that radio show, we get tons of phone calls. We play them back here, and I know, Lior, you like to comment on them. So we'll get to our first one for the day.
I've been at a company 3 years. I've been working here as a supervisor role. With that role, I was on salary, let's say 50 hours a week. Anything above those 50 hours was agreed to be paid hourly, which works out to the same as my salary. Now, what has happened as of recently, the owner has claimed he was unaware of it. He's decided to take away those extra hours above and beyond and change my salary. Is that okay or what? Like, I feel like I'm losing money each week now, putting in the extra hours.
Yeah, pretty much. Yeah.
Well, yeah, it's not fair. So if he has an arrangement with his employer that he's going to get paid certain amounts if you work more than 50 hours, assuming that arrangement is otherwise legal, they have to continue with that arrangement. Can you imagine how silly it is for the employer to say, we didn't know that was the deal? Yeah. And frankly, it doesn't really matter what your boss knew. If that's how you got paid, that is the term of your employment. And we see that often in situations where an employee may have a good deal, And the employer at some point may say, well, wait a second, you have too good a deal. We want to change it. We want to take it back. You can't do that. Your employer can't change the deal just because it doesn't work for the employer, or just because they think you're getting paid too much or they're too generous. Once you have something, it becomes a term of employment. So for this person, if his employer is going to say, we're going to pay you less now, you're still expected to work the same hours, but you're going to get paid less, well, clearly that's a constructive dismissal. An employer does not have the ability and the right to change your compensation in this way. Even though they're not changing salary, they're still reducing pay. So constructive dismissal, he can leave with severance. Natural question is how much severance? So talking about that, and rather than me tell you, let's plug that into the severancepaycalculator.com website. And you can see on the screen, he's a supervisor, 3 years of service. I picked an age, let's say he's 55 years old. Severance calculator correctly assesses him as being owed about 6 months of severance, 6 months pay. Now, this is a situation where he has not been let go. He was not fired. By virtue of the company changing in his compensation, reducing his pay, he can treat that as a termination and get his severance. 6 months pay is what he's owed. What
would happen if the employer said, you know what, I know we can't just say it, but we're going to write you a new employment contract here, and we're going to write that part out of it, and there you go, please sign?
Well, the first thing he'll say is thanks, but no thanks. And why would anyone accept an employment agreement that is less favorable? And that happens. An employer may say, we want you to sign a new agreement. Well, you don't have to. Unless that agreement gives you something of value, something that you want, why would you sign something that changes the terms and makes them worse? You absolutely say, thanks, but no thanks. I'm happy with the deal we currently have. Your employer can't make you. They can't punish you for not signing. Don't sign an employment agreement if you're already employed, because usually that's bad news.
EmploymentHourTV.ca, again, the website to catch one of our radio shows. Phone call number 2 coming up right now.
If I'm with a company for a couple of years, right, and they've come to employee and said, listen, your business is going to be transferred to another company. You're not going to lose any vacation and any years of service. But if you choose to not go over to the company, you're only going to get the minimum 2 weeks per year of severance pay. Should I just go into this new company without taking the package, or take the package that they're going to offer?
I remember that call. We told him, hang on.
No. Well, absolutely. It's not that fast. First of all, what we need to understand is with the new company that's going to offer him a job, what are the terms of that job? Okay? Are they the same terms in terms of compensation, hours, responsibilities, location
too.
Right? Are they the same? If it is the same and he chooses not to accept, just he doesn't feel like it, he doesn't want to work for this other company, he's going to go have a change in careers, that's fine. Then he's owed his minimum severance, which actually could be 2 weeks per year. Now, his full severance would be much more than that, but he would only be entitled to a minimum severance because he's rejecting an offer that's otherwise a reasonable offer. On the other hand, John, if he has a good reason not to accept the job, maybe, again, it's less money, maybe it's a lesser position, maybe he has to move offices somewhere where it's inconvenient.
Or days to nights. Or
days to nights,
right?
Different shifts, different hours. Then at that point, he can reject it and get a lot more severance than 2 weeks per year of service. He'd get his full entitlements based on his age, his position, and the length of his employment. He could go to severancepaycalculator.com to see how much that is. So it comes down to why you're not accepting a job with the company buying the business. And of course, remember, if you are going to accept a job with a company that bought that business, that company inherits your service. So on day one, you have service based on the time you spent with the previous company. And that's especially important if down the road they let you go. Now you're going to get severance based on your total seniority, and that can make a huge difference.
Temporary layoffs is a term we always talk about quite often on this show and on the radio show as well. There's a lot of gray area as far as people, if they've even heard the term or if they know what it means. So we want to get into temporary layoffs and what you need to know. First one right off the top is, what is a temporary layoff and how is it different from, say, a different normal termination of employment?
So a regular termination of employment, sometimes people just refer to that as a layoff. The idea with the termination is you're done. Your job is gone. You're no longer going to be employed with the company, and you're walked out. You're getting paid what you're paid, and you're done. The idea behind the temporary layoff is that, no, we're not letting you go. We're just essentially suspending your employment for a period of time. Putting you on ice. That's a technical term, right? That's right. Putting you on ice for a while. You're not being let go. And at some point, we're going to call you back. Usually, the idea behind that is that maybe the business is slow right now, but we expect or hope that's going to be picking up in a month, in 2 months, in 6 months. And at that point, we're going to call you back. In the meantime, you sit at home patiently and diligently and wait. And then we'll call you back when the business picks up. So regular termination, you're gone. A temporary layoff, the idea is that you're not gone, you're just on ice for a while.
But you're not getting paid, so you're not there.
You're not getting paid, you're not there, and that's where the problems arise. So let me then kind of demystify any misconception that people have here. It's not allowed. Okay, a temporary layoff is a termination. So even though the company hasn't terminated and they're not planning on terminating, you can treat that as a termination. They don't have a right to do that. We talked before on the show always about constructive dismissal. So if I told you that your salary is reduced by 20%, you would say, of course, that's a constructive dismissal. That's a huge pay cut. Well, what is a temporary layoff? We're reducing your pay by 100%, by all of it, nothing. Nothing's left. So that is a termination. When your employer lets you off or lays you off temporarily, you have the option to accept and continue working or treat that as a termination right now and get your full severance.
Is there a pitfall to me accepting it and saying, oh, okay, I'll be a good soldier and suck it out for this one?
Huge pitfall. And the biggest one is the fact that if you accept it, the second time they do it, they can. And the second time they do it, you can't do anything about it. You've given them the right to do it again. So the first time I said you don't have to accept that it's a termination. But you don't want to do that. You're the good soldier. You're going to wait at home for 4 months until they call you back. They call you back. 2 months later, they do it again. At that point, you can't do anything about it. At that point, you're stuck. So it's a very bad situation. I have always said to people, I say this all the time, if your employer lays you off temporarily, you're better off to treat that as a termination rather than create this precedent, rather than create this new term that allows them to do it.
1-855-821-5900 to reach out to any time for a phone call. We were talking about temporary layoffs, what you need to know about it. How much severance is a temporary laid-off employee entitled to receive if it happens?
So if you've been laid off temporarily and assuming the company hasn't done it before, you haven't given them previously the right to do it, you're entitled to your full severance at that point. You can treat that as a termination and get your full severance. Our regular viewers know that you calculate that based on your age, your position, and the length of your employment. Longer you work, older you are, and more senior a position, the more is owed to you. You get same severance as if it was a regular termination. So you go to severancepaycalculator.com, you call me, but there's no discount. It's not a different amount because it's a temporary layoff. It's the exact same severance as if the company had flat out let you go, and it could be a lot of money.
If an employee is listening now and they have just been temporarily laid off, what can they do? What should they do?
Well, first of all, they really want to consider whether or not they're comfortable if this happened again. If they were somehow convinced that this will never happen again, I don't know how you could ever be convinced, but if you were,
once.
Well, maybe you can allow it to happen. I think that's dangerous. So if you've been laid off temporarily, I think you got to consider what's better. To allow this to happen and then it can happen again and again. In the meantime, I'm waiting for months, hoping that they'll call me back. I don't have any paycheck. I may be getting and that's it. So that's option one. Or option two, am I better off to say, no, let me get my full severance. Maybe that's 6 months pay. Maybe that's 24 months pay. And in the meantime, I can find another job. What's better? I think for most people, that second scenario is better. If you're not sure what applies to you, what you should be doing, if you should treat that as a termination, please call me. Let's talk about that. I don't want you to just sit at home waiting to be called back. If you do that, you can create a very bad situation for yourself down the road, and at that point, I may not be able to help you.
Is there any situation where a temporary layoff is allowed?
So really in two scenarios. Number one, if there's an employment agreement that gives the company the power to do that. So again, employment agreements, be very careful what you sign. You may sign an agreement that specifically gives the company the power to lay you off temporarily. I think everyone is home now going to grab their employment agreement.
Read this thing.
Oh my God, because it could say that. Second is if you're in a seasonal business. So if you're working for a company that's clearly seasonal, you're working for a company that builds houses or roofs or pools. So where there's really no work, let's say in the winter, then it's expected. It's an implied term that they can lay you off during the off season. But if you work for a company where that's not a seasonal company, it's not a seasonal business, they don't have a right to lay you off. Even if they're slowing down, they can terminate you with severance or they can allow you to continue working.
When an employment contract is not valid, that and the severance pay calculator all coming up. Want to reach out as we go into a break? No problem. 1-855-821-5900 and employmenthourtv.ca. Employment Hour 30 continues. Hang on.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, welcome back to Employment Hour in 30. John Scholes, Lior Samfiru, 1-855-821-5900. That's one way to reach out. I want to talk about the severance pay calculator as well. SeverancePayCalculator.com. If you have not at least just practice on it, need it for real, here's how you do it, right?
It's huge at parties, by the way. SeverancePayCalculator.com, the very first place, the easiest place to go to, the natural place to go to if you lost your job, if you're staring at a severance letter, if you're trying to make sense of your entitlements and your rights. So easy, SeverancePayCalculator.com, anonymous, easy, free, takes seconds to use, and find out how much you're actually owed if you lost your job. Every time we talk about the severance calculator, I think you maybe noticed that the cameras get a bit shaky here because the people behind the camera grab their phone and check out themselves. Oh, wait a second, how much would I be owed if I get severance, if I've been let go? But in all seriousness, it works because it allows you to get that information so easily, so accessible. Before I created it, the only way you would get that information, you'd have to make an appointment with a lawyer, wait for that appointment, meet with the lawyer. Well, I wanted to make it accessible. So check out SeverancePayCalculator.com, the very first place you go to if you lost your job.
We talk about it, but we always like to put an example in there as well. And I'll give you one right now. Lior says 47-year-old Rick was an IT professional at a major bank for 19 years, earning $63,000 a year. He was let go after being blamed for an expensive mistake that was made by a coworker, not even him. He was offered 19 weeks of severance pay. Was he wrongfully dismissed?
So, John, we come up with these scenarios based on real matters that come across my desk. We changed the names and some of the facts to kind of protect the innocent. But this is a real scenario. And let's talk about the fact that he was let go. So he made a mistake, or maybe someone else made a mistake. At the end of the day, they're allowed to let him go. It's simply a question of severance. Clearly, this appears to be a situation where the company is not saying we're letting you go for cause because they offered him severance.
Right.
So it's despite the fact that he made a mistake or someone else made a mistake, the circumstances don't really factor in. They have to simply pay him severance. So let's talk about that. 19 years of service. They offered him 19 weeks, the old 1 week per year of service. Yeah. So was he wrongfully dismissed? The answer is absolutely yes. Remember, a wrongful dismissal has nothing to do with the reason you're let go. A wrongful dismissal is simply a situation where you're being let go and you haven't been paid proper severance. So if you're offered 19 weeks pay and it should be more than that, it's a wrongful dismissal. So how much is he owed? SeverancePayCalculator.com. Let's plug that in right now. Let's see how much he's really owed. 19 years of service, IT professional, age of 47, making $63,000 a year, offered 19 weeks pay. Well, SeverancePayCalculator.com correctly says, you see on the screen, 18 to 24 months of severance. Now, I can tell you that for him, that's a difference of $70,000 to $100,000. Not $70, not $100, $70,000 to $100,000, because he was offered 19 weeks, which a lot of people would have said, well, that's standard. It's a week per year of service. Not standard, not even close. He's owed as much as 2 years' pay, as much as $100,000 more. Real situation. Don't let that happen to you.
He's got to live on it. He's got to pay his bills, take the kids to hockey, pay a mortgage. So, I mean, $100,000 extra. What he should be getting is a lot of coin.
And it also buys you the time you need to find another job. So you're not desperate. You don't have to take the very first position that comes up, even though it may not be the right choice for you. Take the time that you need to find the right job. That severance is there to carry you, to support your family while you're looking for work.
EmploymentHourTV.ca, that is the place to go to find the radio show, and from it, another phone call for this hour.
I'm actually on a contract that limits my severance entitlement, but I did contact your office, and the woman I spoke to said that I signed it the day that I started working, so she didn't believe that it would be enforceable then, because technically I had started work by the time I signed it.
Yeah, the day of, not before.
So let's unpack this a bit. So he found out when he was let go that sometime before, when he started his job, he signed an employment agreement that limited his severance. So that could be very upsetting, to find out, wait a second, I'm owed 12 months of severance, but because of this employment agreement I signed, now I'm only going to get 3 months of severance. That could be a huge, huge difference. It could be tens of thousands of dollars. Well, because of that, oftentimes we have to assess whether the employment agreement is enforceable or not. And one of the ways it could become unenforceable is if you signed it after you've already started working. So for an employment agreement generally to be enforceable, it has to be signed before you start working. Not on your first day, not on your lunch break, not the second week, before you start working. If you sign it after, then you're not getting anything in return, right? Because you already have a job, you're simply signing the agreement and it's meaningless. So in this particular situation, we looked at the dates and we realized, well, wait a second, you started there on June the 5th, whatever it was, and your employment agreement is dated June the 5th, which means you signed it actually after you started working, when you already had the job. So that meant it was unenforceable. And the reason it was a good thing that it was unenforceable is now there are no terms limiting his severance. So he could get his full severance entitlements, and that's very important. There are several reasons. This is just one of them as to why your employment agreement or the terms that limit your severance, why those may be unenforceable, which is a good thing. So never assume that just because you signed something and it turns out later that it was a bad idea to sign, that it cost you money. Don't assume that it's legal and that it's enforceable. It's always worthwhile making a call. It could be the difference between getting something small and getting your full entitlements, so be very smart.
So the flip side of that, important safety tip, Egon, for employers, have them sign it before they walk through the door. A week, whenever, ahead of time.
Whenever that is, yes. I tell employers that no one shows up to work until they've signed an employment agreement. As simple as that. And ideally, you want to send out the employment agreement when you make someone a job offer, and you want to ask for a response within a couple of days. No one actually has a job, this is what the employer should say, until they sign that agreement. There's no deal, there's no agreement until you return that signed document. Right. If you do that before the employee starts working, it's legal. Otherwise, just like with this caller that we've played, whose voicemail we've played, you'll find out that it's not legal.
Correcting a construction industry myth, and it's a big one. We'll get to that after a short break. 1-855-821-5900 and employmenthourtv.ca as well. Stick around, more Employment Hour 30 is on the way.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hi there, welcome back to Employment Hour in 30. We're going to get to a phone call from our Employment Hour TV show, right? Hour-long show, doing that for many years. You can catch that at employmenthourtv.ca, rather, to find a radio station where you can catch a show, listen, call in, and do the same thing. Phone call number 3 or 4 for this hour is coming up right now.
My husband just got let go on Thursday. He served with this company for 12 years. He's a sole breadwinner for a family, so it's a bit of a shock to us. He was called in on Friday to accept the settlement, but luckily he didn't go in because we had something come up. So we have until Monday now to see what they offer, and he's $75K a year in his position. He is 38, telecommunications, sales.
Very common scenario. Probably this type of call, one of the most common calls that I get in my office. Someone has been let go. They know either they're let go today or they're being let go tomorrow, and they want to know what am I owed. Very common, very simple. And the reason you should be asking that question is because when you're offered that severance letter, when you're holding it in hand and you're walking out to the elevator, always rest assured that that offer is inadequate. In almost every case, it is. In over 90% of cases, it is. You have to assume that. You have to do the right thing and inform yourself with the information. So I can tell you exactly how much this person is owed, but I'll use the severance calculator so that everyone can do that at home. So let's go back to severancepaycalculator.com. Let's plug that information in. So in a sales role, this person, 12 years of service, 38 years old. We know he's making $75,000. He's waiting to see what he's offered, except we already know, as you see on screen, that he's owed 14 to 16 months of pay. Now, based on his salary alone, that's anywhere from $87,000 to $100,000. And again, we don't even know, he may have bonuses and benefits and car allowance and commissions and whatever it is. You know, he's in a sales role, right? So he could be earning commission. Commissions are also included. That's how easy the severancepaycalculator.com website is. That's how easy it is for everyone to find out how much they're owed. Or if you don't want to do that, you'd rather talk to me live, no problem. Call me, email me, and we'll set it up.
TerminationQuestions.com, another great resource for you to ask questions anytime. We'll get to one from here. It says, I signed a 1-year non-compete clause when I first started with the company. I was just fired. Is the clause still valid? Will it hold up if I get a job with the competitor?
So, you know, there's really two questions here. The first question is it valid? Is it enforceable? And the reality is that for most people, a non-competition obligation is not enforceable. It's not legal. Our courts don't like them anywhere here in Canada, and our courts have said that we don't like things that prevent people from earning a living. We don't like things that tell people you can't work. So it's usually not going to be enforceable except for the most senior executives, what we call fiduciaries, the presidents, the vice presidents, the financial officers. For those people, it may be enforceable. For everyone else, usually it's not. So you may think, well, that's it. That's the end of the analysis. Well, this is where the second question comes, and that is the company that you used to work for going to try to enforce it? That's a very different question. And in many cases, the company may try to enforce it and take legal action against you and make your life very miserable. And the fact that it's not enforceable may not prevent them from doing that, to at least try to enforce it. So don't ever sign something or assume that it's not enforceable. If you sign it, you have to live with it. So if you have a non-compete and you're going to breach it, be honest with the company. Tell them that you're going to maintain their confidentiality. You're going to not go after their customers or clients. You just want to be able to work somewhere else. Most reasonable companies will allow you to do that. If you breach the non-compete, even though it may not be enforceable, you may find yourself in the middle of legal action. Not a good place to be in.
TerminationQuestions.com. Again, is that website. I think we got time to slide one more in here. Got a couple minutes to go. It says, my boss just laid me off after 6 years. When I asked for my 2 weeks pay, he laughed and said that construction workers don't get 2 weeks pay or anything else when they're fired. Is that true?
Well, I'm glad that his boss said that, because then he would have only gotten 2 weeks pay and he would have said that's fine. That's silly. That's ridiculous. Construction employees, in the eyes of the law, are treated the same as any other employees when it comes to severance. So there's a big misconception that if you're in construction, you don't get severance. That is a misconception. That is wrong. That is false. Not only do you get severance, you get the same amount of severance as everyone else based on your age, your position, and the length of your employment. Now, your minimum entitlements may be different if you're in construction, but your full entitlements are the same. So this person, after 6 years, is not owed 2 weeks pay. He could be owed 8 months pay, 9 months pay. So I'm glad his employer says, I'm not going to pay you 2 weeks, because they're going to owe him much, much more than that. If you're in construction, if you lost your job, check out severancepaycalculator.com. Call me. You're owed severance.
Quickly, where does that come from? Why this misconception?
Under the Employment Standards Act, there may be exemptions to employees when it comes to their minimum entitlements if they're in construction. But that's only with respect to your minimum entitlements. Your full entitlements, what we call your common law entitlements, are the same. Bottom line is, you get severance if you're in construction.
A lot of stuff on the show today. You want to follow up. Again, that was TerminationQuestions.com, where we pulled those 2 questions from. 1-855-821-5900 is the email anytime to get a hold of Lior, member of his team. And we know this already. Always go to severancepaycalculator.com when you want to find out how much you're really owed. It is free. You can't put a Visa number. Anything else in there is absolutely anonymous if you want it to be. It takes about 30 seconds. My daughter could use it if she wanted to. Not that she's working yet. I'm not that type of dad. EmploymentHourTV.ca as well is a website to find the radio show. Till next time, this has been Employment Hour in 30. We'll see you next time.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.